Evidence. Any information, material, or testimony presented to the court to prove or disprove facts at issue in a case, governed by strict rules determining what may be considered by the jury or judge in reaching a verdict. Rules of evidence. The body of procedural law governing what evidence may be admitted at trial, how it must be presented, and what weight it may be given, designed to ensure that only reliable, relevant, and fair evidence reaches the fact finder. Admissibility. The legal determination of whether specific evidence meets the requirements of the rules of evidence and may therefore be presented to the jury based on factors including relevance, reliability, and the absence of unfair prejudice. Inadmissible. A designation applied to evidence that fails to meet the legal standards required for admission at trial, meaning it must be excluded from the jury's consideration regardless of how probative or compelling it might otherwise be. Foundation. The preliminary showing an attorney must make before introducing evidence, establishing the basic facts necessary to demonstrate that the evidence is what it purports to be and that it meets the threshold requirements for admissibility. Laying the foundation. The process by which an attorney establishes through witness testimony or other means the necessary background facts to authenticate evidence and satisfy the court that the evidence is reliable enough to be admitted. Proffer. A presentation made outside the jury's presence in which an attorney offers a preview of what evidence or testimony will show, allowing the judge to rule on admissibility without exposing the jury to potentially inadmissible material. Weight of the evidence. The persuasive value or degree of credibility the jury assigns to admitted evidence in reaching its verdict, distinct from admissibility. Evidence may be technically admissible, but given little weight by the jury. Sufficiency of the evidence. The legal standard asking whether the evidence admitted at trial is adequate to support the verdict reached, used as the basis for post-trial motions and appellate review challenging whether a reasonable jury could have decided as it did. Stipulation. A formal agreement between opposing counsel that a particular fact is true and need not be proven at trial, accepted by the court and presented to the jury as an established fact, saving time and focusing the proceedings on genuinely disputed issues. Judicial notice. The court's acceptance of a fact as established without requiring formal proof, available for facts that are either commonly known within the jurisdiction or can be accurately and readily determined from unquestionable sources. Relevance. The fundamental threshold requirement for admissibility, asking whether the evidence has any tendency to make a fact of consequence to the case more or less probable than it would be without the evidence. Relevant evidence. Evidence that has a logical connection to a fact at issue in the case, making the existence of that fact either more or less likely, and therefore potentially useful to the jury in reaching its verdict. Irrelevant evidence. Evidence with no logical connection to any fact at issue in the case, which must be excluded because it cannot assist the jury in determining any matter of consequence and would only waste time or confuse the issues. Material fact. A fact that is significant to the outcome of the case, one that actually matters to the legal issues being decided, as distinguished from background facts that may be true but have no bearing on the verdict. Probative value. The degree to which a piece of evidence tends to prove or disprove a fact at issue, serving as the positive side of the admissibility balance that must be weighed against the potential for unfair prejudice. Unfair prejudice. The risk that evidence, even if relevant, will lead the jury to make a decision based on emotion, bias, or improper reasoning rather than on the actual facts, justifying exclusion when its prejudicial effect substantially outweighs its probative value. Balancing test. The judicial weighing of probative value against the risk of unfair prejudice, confusion of issues, or misleading the jury, used to determine whether relevant evidence should nevertheless be excluded in the interests of a fair trial. Curative instruction. A judge's direction to the jury to disregard evidence or testimony that has been improperly admitted or spontaneously blurted out, instructing them to strike it from their minds in their deliberations. Door opening. The legal principle that when one party introduces evidence or makes an argument on a particular topic, the opposing party may introduce otherwise inadmissible evidence to respond, rebut, or provide context for what was introduced. Direct evidence. Evidence that directly proves a fact without requiring any inference or presumption, such as an eyewitness who testifies to personally seeing the defendant commit the act in question. Circumstantial evidence. Evidence that does not directly prove a fact, but allows the jury to draw a reasonable inference that the fact exists, such as fingerprints at a crime scene or a defendant's motive and opportunity. Physical evidence. Tangible, material objects presented at trial that can be seen, touched, or examined, such as weapons, documents, clothing, photographs, or any other item relevant to the facts of the case. Documentary evidence. Written or recorded materials offered as evidence, including contracts, letters, emails, medical records, financial statements, photographs, and any other documents relevant to proving facts in the case. Demonstrative evidence. Evidence created specifically for trial to help illustrate, explain, or summarize other evidence or testimony, such as charts, diagrams, maps, timelines, models, or computer animations, which is not itself a piece of the original event. Testimonial evidence. Evidence presented through the sworn statements of witnesses speaking in court or by deposition, constituting the most common form of evidence and the foundation of the adversarial trial system. Digital evidence. Electronically stored information used as evidence at trial, including emails, text messages, social media posts, computer files, metadata, surveillance footage, and GPS data, subject to special authentication and preservation requirements. Real evidence. The actual physical objects directly involved in the events at issue in the case. The murder weapon, the forged document, the defective product, as opposed to demonstrations or reproductions created for trial. Exhibit. Any item of physical, documentary, or demonstrative evidence formally marked, identified, and offered into the official record of a trial, assigned a number or letter designation for reference throughout the proceedings. Best evidence rule. The requirement that when the contents of a written document are at issue, the original document itself must be produced rather than a copy or a witness's recollection of what it said, unless the original is unavailable for a legitimate reason. Secondary evidence. A copy, reproduction, or oral account of the contents of an original document admissible only when the original has been lost, destroyed, or is otherwise unavailable, and its absence is satisfactorily explained. Witness. Any person called to testify under oath at a legal proceeding whose statements constitute testimonial evidence and who may be subject to cross-examination by the opposing party. Competency. The legal qualification of a witness to testify, requiring that they have personal knowledge of the subject matter, understand the obligation to tell the truth, and be capable of communicating their observations to the court. Personal knowledge. The requirement that a witness may only testify about facts they directly observed or experienced themselves, prohibiting testimony based on what they heard from others or merely assumed to be true. Oath. The solemn promise made by a witness before testifying that their statements will be truthful, the violation of which constitutes the crime of perjury. Affirmation. A secular alternative to a religious oath, allowing a witness who objects to swearing by a deity to make a solemn non-religious declaration that their testimony will be truthful, carrying the same legal weight and consequences. Perjury. The criminal offense of knowingly making a false statement under oath in a judicial proceeding, one of the most serious violations a witness can commit, as it strikes at the integrity of the entire justice system. Direct examination. The initial questioning of a witness by the attorney who called them to the stand, conducted using open-ended questions designed to elicit the witness's narrative account of the relevant facts. Cross-examination. The questioning of a witness by the opposing attorney after direct examination, typically using leading questions designed to challenge the witness's credibility, expose inconsistencies, or elicit facts favorable to the cross-examining party. Redirect examination. A follow-up round of questioning by the attorney who originally called the witness, conducted after cross-examination and limited to addressing the specific topics raised during cross-examination. Re-cross-examination. A final round of questioning by the opposing attorney, conducted after redirect examination and typically limited to the new matters raised during redirect. Leading question. A question that suggests the desired answer within the question itself, generally prohibited during direct examination, but permitted during cross-examination as a tool for controlling the witness and testing their account. Non-leading question. An open-ended question that does not suggest a particular answer, required during direct examination to allow the witness to provide their own account in their own words without being coached by the questioning attorney. Hostile witness. A witness who demonstrates open antagonism or bias toward the party who called them, allowing the calling attorney to treat them as an adverse witness and use leading questions during what would otherwise be direct examination. Adverse witness. A witness called by one party who is identified as aligned with or favorable to the opposing party, permitting the calling attorney to use cross-examination techniques, including leading questions during direct examination. Impeachment. The process of attacking a witness's credibility to convince the jury that their testimony should not be believed, accomplished through prior inconsistent statements, evidence of bias, prior convictions, or contradiction by other evidence. Prior inconsistent statement. A statement made by a witness on a previous occasion that contradicts their current trial testimony, admissible to impeach the witness's credibility by showing that they have not been consistent in their account of the facts. Rehabilitation. The process of restoring a witness's credibility after it has been attacked on cross-examination, typically accomplished through redirect examination, prior consistent statements, or evidence rebutting the basis of the impeachment. Corroboration. Additional independent evidence that supports or confirms the testimony of a witness, strengthening the reliability and believability of that witness's account in the eyes of the jury. Recantation. A witness's formal withdrawal or repudiation of testimony previously given under oath, which may itself be subject to scrutiny and can cut either way depending on whether the original or revised account appears more credible. Expert witness. A witness with specialized knowledge, skill, experience, training, or education in a particular field who is permitted to offer opinions, not just factual observations, to help the jury understand technical or complex matters beyond common knowledge. Expert opinion. The professional judgment or conclusion offered by a qualified expert witness based on their specialized knowledge and analysis of the facts, going beyond what a lay witness is permitted to say. Daubert standard. The federal standard for admitting expert testimony, requiring the trial judge to act as a gatekeeper and evaluate whether the expert's methodology is scientifically valid, has been tested, peer-reviewed, and is generally accepted in the relevant scientific community. Frye standard. An older standard for expert testimony admissibility, still used in some states, requiring only that the scientific technique or theory underlying the expert's opinion be generally accepted within the relevant scientific community. Qualification. The process by which an attorney establishes through testimony about the expert's education, training, and experience that the witness meets the legal standard to offer expert opinions in a particular subject area. Voir dire of expert. A mini-hearing conducted before an expert testifies in which the opposing attorney questions the proposed expert about their qualifications, allowing the court to rule on whether the witness is sufficiently qualified to offer expert opinions. Hypothetical question. A question posed to an expert witness asking them to assume certain facts are true and then offer an opinion based on those assumed facts, used when the expert has not personally observed the events at issue. Battle of the experts. The common trial situation in which both sides present competing expert witnesses who offer conflicting opinions on the same technical issue, leaving the jury to determine which expert's methodology and conclusions are more credible and reliable. Treating physician. A doctor who provided medical care to a party and may testify about their observations, diagnosis, and treatment without necessarily being retained as a formal expert witness, occupying a hybrid role between lay and expert witness. Hearsay. An out-of-court statement made by a person other than the testifying witness that is offered to prove the truth of the matter asserted in the statement, generally inadmissible because the person who made the statement cannot be cross-examined. Declarant. The person who made the out-of-court statement that is being offered as evidence, whose credibility and demeanor cannot be assessed by the jury because they are not testifying under oath at trial. Truth of the matter asserted. The critical element of hearsay, referring to the use of an out-of-court statement as proof that what it says is actually true. If the statement is offered for any other purpose, it is not hearsay and may be admissible. Non-hearsay use. A purpose for which an out-of-court statement may be admitted without implicating hearsay rules, such as to show the effect the statement had on the listener, to prove the statement was made regardless of its truth, or to establish notice. Hearsay within hearsay. A situation in which an out-of-court statement contains another out-of-court statement, requiring each layer to independently qualify under a hearsay exception for the combined statement to be admissible. Present sense impression. A hearsay exception permitting admission of a statement made while the declarant was perceiving an event or condition, or immediately thereafter, on the theory that there was no time for deliberate fabrication. Excited utterance. A hearsay exception allowing admission of a statement made while the declarant was under the stress of excitement caused by a startling event, on the theory that the emotional state guarantees spontaneity and reduces the likelihood of fabrication. State of mind exception. A hearsay exception permitting admission of a statement reflecting the declarant's then existing mental, emotional, or physical condition, such as intent, plan, motive, or fear, when that state of mind is directly relevant to the case. Dying declaration. A hearsay exception allowing admission of a statement made by a declarant who believed their death was imminent concerning the cause or circumstances of what they believe to be their impending death, based on the theory that people are unlikely to lie on their deathbed. Statements for medical diagnosis or treatment. A hearsay exception permitting admission of statements made by a patient to a medical provider describing symptoms, pain, or the cause of an injury when made for the purpose of receiving medical diagnosis or treatment. Business records exception. A hearsay exception allowing admission of records kept in the regular course of a legitimate business activity made at or near the time of the events recorded by someone with personal knowledge, provided they were kept as a matter of regular business practice. Public records exception. A hearsay exception permitting admission of records, reports, or data compilations of public agencies setting forth their activities, matters observed pursuant to a legal duty, or factual findings from official investigations. Prior testimony exception. A hearsay exception allowing admission of testimony given at a prior proceeding, such as a deposition or earlier trial, when the declarant is now unavailable and the opposing party had an opportunity to cross-examine them at the time. Admission by a party opponent. A statement made by a party to the litigation that is offered against them by the opposing party, not technically considered hearsay under the rules because a party cannot object to the use of their own prior statements. Adoptive admission. A statement made by someone other than the party that the party adopted as their own, through words, conduct, or silence in circumstances where a denial would be expected. and which may therefore be used against them. Co-conspirator statement. A statement made by a member of a conspiracy during and in furtherance of the conspiracy, admissible against all co-conspirators as a party admission, even though the person who made it is not the defendant on trial. Residual exception. A catch-all hearsay exception permitting admission of a statement not covered by any specific exception when it has equivalent guarantees of trustworthiness is offered on a material fact, and admitting it would best serve the interests of justice. Confrontation clause. The Sixth Amendment right of a criminal defendant to confront the witnesses against them, which limits the use of certain out-of-court testimonial statements even when they fall within a hearsay exception. Privilege. A legal protection that shields certain communications or relationships from compelled disclosure in legal proceedings, recognized because preserving the confidentiality of these relationships is considered more important than obtaining the evidence. Attorney-client privilege. The protection shielding confidential communications between an attorney and their client made for the purpose of seeking or providing legal advice. One of the oldest and most sacrosanct privileges in the law. Work product doctrine. The protection shielding an attorney's mental impressions, conclusions, opinions, legal theories, and trial preparation materials from disclosure to opposing counsel, recognizing the importance of allowing attorneys to work without fear of exposure. Physician-patient privilege. The protection shielding confidential communications between a patient and their doctor made in the course of seeking medical treatment, though its scope varies significantly by jurisdiction, and it may be waived by placing medical condition at issue. Spousal privilege. A privilege protecting confidential communications between spouses, taking two forms: the marital communications privilege, protecting private conversations, and the testimonial privilege, allowing a spouse to refuse to testify against their partner in criminal proceedings. Clergy penitent privilege. The protection shielding confidential communications made to a member of the clergy in their professional capacity as a spiritual advisor, recognized in virtually every jurisdiction as essential to the practice of religion. Psychotherapist-patient privilege. The protection shielding confidential communications between a patient and a licensed mental health professional, broadly recognized as essential to effective therapy and the encouragement of honest disclosure. Fifth Amendment privilege. The constitutional right of any witness, not only defendants, to refuse to answer questions that could expose them to criminal prosecution, exercisable in any proceeding including civil trials, depositions, and congressional hearings. Waiver of privilege. The voluntary or inadvertent relinquishment of a privilege, which can occur through disclosure of privileged communications to third parties, placing privileged matters directly at issue in litigation, or failing to assert the privilege in a timely manner. Crime-fraud exception. An exception to the attorney-client privilege and work product doctrine, providing that communications made in furtherance of a future crime or fraud are not protected, as the privilege was never intended to shield ongoing criminal activity. Authentication. The process of proving that a piece of evidence is what the offering party claims it to be, a threshold requirement for admissibility that must be satisfied before the jury is permitted to consider the evidence. Chain of custody. The documented chronological record tracking who collected, handled, transferred, and stored a piece of physical evidence from the moment it was gathered through its presentation at trial, essential for establishing that the evidence has not been altered, contaminated, or tampered with. Self-authenticating evidence. A category of documents and items that are considered authentic on their face without requiring extrinsic evidence, including certified public records, official publications, notarized documents, and newspapers. Handwriting authentication. The process of proving that a handwritten document was written by a particular person, accomplished through testimony of someone familiar with the person's handwriting, expert comparison, or submission to the jury for comparison. Voice identification. Authentication of a recorded or telephone communication by a witness who identifies the speaker's voice based on familiarity gained before or after the communication, or through other circumstantial evidence. Photograph authentication. The process of establishing that a photograph accurately depicts what it purports to show, typically accomplished through testimony of a witness with personal knowledge that the image is a fair and accurate representation. Metadata. Embedded digital information describing the origin, creation date, modification history, and other characteristics of an electronic file, increasingly important in authenticating digital evidence and establishing when and how documents were created or altered. Tampering. The unauthorized alteration, modification, or interference with physical evidence, which if proven can result in exclusion of the evidence, sanctions against the responsible party, or independent criminal charges. Burden of proof. The obligation of a party to establish a fact or claim to the level of certainty required by the applicable legal standard, determining who bears the risk of failing to persuade the fact finder. Burden of production. The obligation to introduce sufficient evidence on an issue to have it considered by the jury, a threshold requirement distinct from the burden of persuasion that determines the outcome. Burden of persuasion. The obligation to convince the fact finder that the facts support the party's position to the degree required by the applicable standard of proof, which remains fixed throughout the trial regardless of how the evidence unfolds. Beyond a reasonable doubt. The highest standard of proof in the legal system required for criminal conviction, meaning the prosecution must present evidence so convincing that a reasonable juror would have no significant doubt about the defendant's guilt. Preponderance of the evidence. The standard of proof in most civil cases requiring the party bearing the burden to show that their version of events is more likely true than not. Essentially, a greater than 50% probability that their position is correct. Clear and convincing evidence. An intermediate standard of proof, higher than preponderance but lower than beyond a reasonable doubt, required in certain civil proceedings such as fraud claims, termination of parental rights, and civil commitment. Prima facie case. A Latin term meaning at first sight, referring to the minimum amount of evidence a party must present on each element of their claim to survive a motion to dismiss or directed verdict and have the case submitted to the jury. Rebuttable presumption. A legal assumption that a court will make in the absence of contrary evidence, which the opposing party may overcome by presenting sufficient evidence to the contrary, shifting the burden back to the original party. Irrebuttable presumption. A legal conclusion that the court treats as absolutely established once certain foundational facts are proven, which cannot be overcome by contrary evidence, regardless of how compelling that evidence might be. Exclusionary rule. The judicial doctrine requiring that evidence obtained by the government in violation of a defendant's constitutional rights be excluded from use at trial, serving as the primary remedy for constitutional violations by law enforcement. Motion to exclude. A formal request asking the court to bar specific evidence from being presented at trial based on a violation of the rules of evidence, constitutional requirements, or prior court orders governing the case. Limiting instruction. A judge's direction telling the jury that certain admitted evidence may only be considered for a specific limited purpose and must not be used as proof of other matters. Used when evidence is admissible for one reason, but could cause unfair prejudice if used more broadly. Curative instruction. A judge's direction ordering the jury to disregard evidence or testimony that was improperly admitted, instructing them to treat it as if they never heard it in their deliberations. Harmless error. An evidentiary ruling that was technically incorrect but did not affect the substantial rights of the parties or the outcome of the trial, insufficient to justify reversing the verdict on appeal. Reversible error. An evidentiary ruling or other trial error serious enough that it likely affected the outcome of the trial, providing grounds for an appellate court to reverse the verdict and order a new trial. Plain error. An obvious and serious error that was not objected to at trial, but is so fundamental that an appellate court may review and correct it in the interests of justice, even though the party failed to preserve the issue below. Contemporaneous objection rule. The requirement that an attorney object to inadmissible evidence at the time it is offered, rather than waiting until later, failing which the objection is generally waived and cannot be raised on appeal.